Okay, and we're rolling. Here's another edition of Car Brief, the web channel that brings to you the most interesting case law that's out there that pertains to automotive liability, race car situations, general traffic, laws violated, and so on. Tonight I have a very interesting case. This was an oldie but a goodie. It goes back to a decision that was made in March of 1991. This involved a drag car that hit a deer at a drag strip. Actually, it was Byron Dragway in Illinois. So we're going to figure out what the court decided with regards to liability when this individual, this race car driver, hit a deer and unfortunately he lost his life. This is the case of Simpson versus Byron Dragway. And the facts are essentially as follows. The plaintiff's decedent, the plaintiff was Lyle Simpson, the actual administrator of the estate of Jerry Simpson, the decedent, and they appealed from a decision made at the trial level in the second district. It was a Winnebago case, and the trial court granted the defendant, NHRA and Byron Dragway's motions for summary judgment, which means there's no genuine issue of a material fact. It's essentially saying, hey, you filed a suit, but there's no genuine issue here. There's no responsibility. There's no liability. And we filed these motions to get out of the case. And the trial court agreed and dismissed both defendants, actually NHRA and Byron Dragway, because they held that the release that was signed by the race car driver before he got into his drag car and went down the track, that release was acceptable. That was an effective release. It released the liability of both parties, and because of that, the plaintiff appealed. So that's what brings about this case on appeal in the second district. And essentially the facts are as follows. On August 3rd of 1986, it just goes to show how long these cases last. On August 3rd of 1986, the decedent, a licensed and experienced race car driver, was killed when his drag car collided with a deer during a race at the dragway. On April 3rd of 1987, his estate filed a 3-count complaint against the dragway, which sought damages for wrongful death, pain and suffering, and property loss. Well, on May 20th of 1988, the estate then filed a 9-count amended complaint, which had the NHRA as a defendant, and sought damages based upon negligence and willful and wanton conduct. Well, willful and wanton is essentially conduct where there is an intent or an abandoned disregard for the safety of others. And it's a higher standard, it's a tougher burden to meet, but sometimes plaintiff lawyers will file willful and wanton if the facts merit it, and apparently they believe that it merited it in this case. Well, the court determined that the release that was effectively, the release that the plaintiff's decedent signed was effectively precluding liability against the dragway, and that there was no facts to support the plaintiff's willful and wanton conducts. Especially with regards to the NHRA, the court held that it did not exercise ownership or control over the dragway. So NHRAs are a sanctioning body for drag racing. They didn't own the property where the fatality occurred. They're essentially a facilitator for the drag racing. So really, the court, they said that their summary judgment was proper because they didn't actually own the property where the accident happened. Well, the release that was signed by the race car driver essentially stated that the release limits your right to recover of damages in case of accident, and read it before signing. The release went on to say that in applying to enter this race, I promise that I will inspect the track prior to running on it, will assure myself that the track and adjacent areas are properly designed and maintained, and further agree that I will not participate in this race until I have completed an inspection which satisfies me that these areas are safe for race purposes. I will further note existing weather conditions and do agree that I voluntarily assume all risks arising from conditions related to use of the track area by myself or others. I do agree to hold harmless and indemnify the owners and possessors of this track for any loss, cost, expense, damages, or injury arising from my participation in this event. So he signed off on that document. That was pretty clear. There was no ambiguity there. However, According to the track announcer, Roger Millsap, the decedent began his run shortly before 1 p.m. and approximately midway through the run, Millsap observed a deer leave the wooded area beyond the racetrack and start to run toward the track. Shortly after the decedent's dragster passed the finish line, it struck the deer. And Millsap described the impact as a big burst of red blood, and the dragster seemed to come to a stop quite abruptly. After the impact, Millsap announced to the spectators that he knew this was going to happen, and that's key here in this case. Millsap indicated that he made the statement because he could see that the dragster and the deer were going to make impact. But did he really? Why did he really say that? Well, it goes on to state that Millsap, the announcer, left the control tower and went down to the decedent's dragster, and the decedent's brother had managed to pull the decedent from the dragster. When the announcer arrived, the ambulance crew was present, and the decedent was still alive at that time, but he died shortly thereafter. He observed that the individual was coughing, and the left side of his body appeared to be crushed. It sounded like a terrible accident, absolutely god-awful. I mean, deer, when they spring out, even with a regular streetcar, it can have really disastrous results. It was Millsap's belief that the decedent never saw the deer before the impact, and he was also a race car driver and believed that the dragster that was driven by the decedent restricted the driver's vision to being able to see only straight ahead. So I'm thinking it was probably one of those long type rail drag cars, dragsters, rather than your funny car with the fiberglass body and then the tubular chassis inside. Millsap, the announcer, pointed out that the decedent did not apply his brakes before the impact because he completed the quarter-mile run in 8.95 seconds. Now, that's a fast run. The Dodge Demon that came out about a year and a half ago or so, it does the quarter mile in 9.65 seconds. It's fast enough to lift the wheels off the ground. Anything under a 10-second car is pretty damn fast, I would say. Pretty fast. Millsap further indicated during his deposition that the length of the racetrack was 1,320 feet, and there was another 1,000 feet beyond the finish line to enable the cars or dragsters to slow down. A guardrail ran the entire length of the 1/4 mile track. There was a 4-foot-high chain link fence that protected the grandstand. Millsap stated that he saw deer near the finish line during the summer of 1986, approximately 2 months before the accident. He didn't stop the racing at that time because the deer were not on the drag strip. However, he was at the Dragway in 1984 as a spectator when races were halted due to the presence of deer in the vicinity of the track. This wasn't a common occurrence. This was not a common occurrence, but it did happen prior to this accident. That suggests that the drag strip was on notice of this problem. This wasn't something new, although not common. It wasn't something new and something that they did not know about or possibly foresee. Well, the owner of the facility indicated that he saw deer at the edge of the racetrack on another occasion before August 3rd of 1986. However, the deer did not enter the track, and the racing was not halted. He denied stopping the races in 1984 due to the presence of deer. He did not see any deer near the dragway prior to 1986. However, he did remember seeing a group of dogs from a nearby hound club approach the track in 1984, but the racing was not stopped because the dogs appeared during the intermission. Looks like there were creatures or animals that were able to get onto this track, albeit at the end of the track toward the finish line, but they were still able to get on the track. And a lot of these drag strips, they're out in the middle of nowhere. And is it reasonable to expect that animals could get onto the track? Yes, but is it reasonable to expect the owners of the facility to regulate each and every animal in the area? Sometimes these animals get on there of their own volition. Well, the whole thrust of the case devolved around this release. Was it a release that was significant or enough to prevent liability on the part of the defendants? And the court noted that typically releases are going to be enforced unless they find that it violates the public conscience. There are situations where releases are not applied, and this turned out to be one of those cases. The court held that the release was not sufficient to prevent liability from attaching to the defendants. The appellate court indicated the defendant, NHRA, did not own or control the land in the case at bar, so they affirmed the dismissal of the NHRA from this case. They didn't own the land. At most, they were just a sanctioning event that meant that they awarded points for performance at the event. They didn't own the track or otherwise control it on the day of the question. Absent any evidence of ownership, the NHRA, they're out of the case. So that part of the trial court decision was correct, according to the appellate court. NHRA, they stayed out of the case. However, Byron Dragway, different situation. The court went on to look at the release language that was prepared by Byron Dragway, and essentially releases indicate that there is an express assumption of risk and that one party is consenting to relieve another party on a particular obligation. But in order to effectively assume the risk of some occurrence, it must be demonstrated that the danger which caused the injury was one which ordinarily accompanied the activity, and the plaintiff knew or should have known that both the danger and the possibility of injury existed before the occurrence. Well, the court looked to deer on the track. Is that something that the plaintiff could reasonably have foreseen would be a problem or an encounter that he would deal with on the track? And the court said, no, that's not something that when he signed the release, it would be something he could reasonably foresee or assume that that is part of auto racing or drag racing. The plaintiff argued that striking a deer, which operates a striking of a deer while operating a race car on a drag strip, is not the type of risk which ordinarily accompanies the sport. The court agreed with the plaintiff in that, and as a result, the appellate court reversed the trial court and allowed the case to proceed on the negligence part of the case. The release was no good. It wasn't enough to let the drag strip out on the negligence count. Now the court addressed the issue of the willful and wanton. Is this something that the defendant drag strip knew or reasonably should have known that it was presenting a danger and just blindly said, well, yeah, sometimes it happens, but we really don't care. We're not going to do anything to stop it. That is essentially willful and wanton conduct, or something that's recklessly negligent. The court held that that was a question of fact, too, because of the prior history, the prior knowledge of the defendant drag strip. They knew about deer getting on the track in the past. Therefore, it was a question for a trier of fact to make the determination, the trier of fact being typically the jury, if it's a jury trial, to make the determination whether there was a willful and wanton conduct on the part of the defendant. The court reversed the appellate court reversed the trial court and said, yes, in fact, the plaintiff can go forward on the evidence as far as willful and wanton conduct. Willful and wanton negligence, that is. Well, what about a situation where a meteor strikes the drag car out of the blue and destroys the drag car and kills the race car driver? Would the drag strip be liable for that? Is that something that's foreseeable during a drag race? Probably not. That would be outside the scope of the release. Would a court hold the drag strip liable for that? I don't think they would, because it's not something that's reasonably foreseeable, and it's ultimately boils down to what control did the drag strip have to prevent a meteor from crashing into the drag car during a race. They have no control over that. They'd have no notice whatsoever of that. Plus, they'd have no negligence. There's no way they could stop something like that from happening. So the situations turn on their facts. Deer, you may have a duty to keep that under control. So negligence is a duty to do something. You breach that duty, and as a result of the breach, there's a proximate cause. It means you're the cause, or the next two cause, or the cause in fact for the injury sustained, but you also have to have damages. And clearly, there are damages in this case as well, because unfortunately this driver died. Very unfortunate set of circumstances. And the court, well, in the end, they allowed the case to go forward. How it turned out in the end, I'm not certain. They may have settled the case after the appellate court reverse the decision and send it back to the trial court. A lot of times that does happen, and then we don't get the story thereafter. But the appellate case is a printed case. It's in Court Reporters in Illinois, 2nd District. You can look it up. I'm Richard Elsayer. I practice law in Chicagoland. I handle personal injury, a variety of other types of law, including bankruptcy and traffic law, which are my focused areas. And all I can say is the takeaway: read your release carefully before you sign it. They probably won't let you engage in the activity until you do sign the release. But know this, that you may have a remedy if something untoward does happen, and you may want to explore that avenue. And we'll sign off for now. Happy motoring, and there will be many more cases out there that I will report upon. Enjoy the evening and take care.